Welcome to today's presentation of the NeuroTech program. My name is David Black. I'm a patent attorney with the Schwegman Law Firm in Minneapolis, Minnesota. Today we are talking about some different strategies that will become important for the growth of your new business. And this will help you navigate the waters and build your portfolio. So, first thing we should talk about here is concerning the difference between a patent and a trade secret. It's important to recognize that they are on opposite ends of the spectrum. You can think of it as a continuum, where a trade secret and a patent represent a fork in the road, and we have to make a selection. And that occurs with regard to many of the technical developments that you're probably working on now. So, with regard to a trade secret, we think of that in terms of information that you know and it's not known by others, and that because you know this information, it provides you with a commercial advantage. It has a very, very broad scope. It can cover things that a patent won't touch, and it can cover things that might be known in an abstract manner, but compiled all together, it becomes a trade secret that does have this commercial value. And it's something that you alone enjoy the benefit of because it's something that you know. That's your trade secret. On the other hand, when we think about a patent, we're thinking about a bargained exchange. And in this sense, we are exchanging the information you know about this technology for a government-granted right which allows you to exclude others for a limited amount of time. So that's the difference. The difference is one is an exchange and the other is just purely concealment. Okay, so that's a trade secret and a patent on a high level. Let's think a little bit more with regard to a trade secret. The interesting thing there is it has there's no limit in terms of the technical scope or what kind of content is eligible for protection by way of a trade secret. There's no limit with regard to the duration by which you can enjoy this trade secret benefit. The limitation, of course, is once it becomes known, it's no longer a secret, and therefore you lose the ability to control it anymore. A trade secret, some people think of as a trivial cost. You know, it doesn't cost you anything. Patents are so expensive. Let's just get a trade secret here. Well, trade secrets also incur costs, and the cost to have a trade secret are all of the accompanying expenses you incur and the burden and the friction to maintain that secret. And so that can be extremely substantial in terms of limiting the access to the information, figuring out what the definition of that information really amounts to, what's the scope of that protection, and who has the rights to it, and how do we make sure that information doesn't wander off. So a trade secret comes with a non-trivial burden, that is the cost to maintain that secret. And one of the vulnerabilities, of course, with a trade secret is if others reverse engineer your information, if it leaks out, if others figure this out or study your problem and situation and find the answer, the trade secret's gone. So that's when things go bad. When the trade secret goes sideways and the cow has left the barn, there's nothing we can do to put it back in. It becomes especially difficult in the context of litigation from the standpoint that there are discovery mechanisms, and by its very nature, litigation is looking to uncover what's at the core, and that could well be your trade secret. So where it might not have been disclosed broadly at the outset of the litigation, at the conclusion of the litigation, it might be pretty well known. A patent, on the other hand, let's think about that for a moment. It has specific criteria with regard to what type of subject matter is eligible for a patent. The United States Patent and Trademark Office, for example, likes to grant patents for technical innovations. And for a number of years, there was some great difficulty at the Patent Office with regard to what kind of software inventions really amount to a technical innovation. And do we allow patents for these, yes or no? Well, that question has long since been settled. But nevertheless, there are certain technical areas which still are subject to a prejudice from the Patent and Trademark Office, which makes it particularly challenging for applicants to get granted patents. So, the criteria for getting a patent, a couple of the key ones concern subject matter eligibility. It has to be the sort of thing for which the Patent Office likes to grant patents. It has to be sufficiently novel, that means not previously known, and it has to be sufficiently non-obvious. So this question of non-obviousness gets to the matter of something special. Where's the secret sauce? What kind of interesting thing is going on here that we didn't know about? The idea, as we mentioned at the outset, talks about this bargained for exchange in terms of a patent. And we think of society as knowledge continuously growing. And we're on this march to ever increasing and expanding knowledge of our world. And if we're just 2 weeks away from understanding the subject matter for which you're standing before us now and asking for a patent, we're likely to say, no, we'll just wait another 14 days and we'll have figured that out. So we're going to say that's not obvious. It's not sufficiently non-obvious. And so we're going to say we know where that's going to take us. And so we don't need to pay the price to give you an exclusive use or access to this technology for the next 20 years. So instead, we'll just treat this as an obvious change and therefore not eligible for patent protection. So that becomes the challenge. We have to find some kind of a solution. The inventor has to find some kind of a solution or some kind of a technical innovation that represents a non-obvious improvement. And those are the things for which the Patent Office will easily grant a patent, provided the other conditions are satisfied as well. But if, on the other hand, it's a pretty obvious configuration of arrangement of components that we all know about and we are all familiar and they work exactly as we expect, you're going to have a little harder time getting that through the Patent and Trademark Office. So, can an innovation be reverse engineered with regard to a patent? Well, of course it can. Somebody's going to look at your patent, understand it, because the obligation on the applicant, of course, is to disclose it with sufficient detail so others can practice your innovation. And they'll look at your document, they'll scrub it head to toe, and they'll look for the next improvement that's not mentioned in your document and find opportunities to make changes and alter your improvement. And so that's exactly what the Patent Office the patent system is trying to do. It's trying to foster the distribution of information and promote the growth of our sciences and engineering and human life. And by sharing this information and spreading it and distributing it in a manner that's published, we're standing on the shoulders of the giants before us. So another thing that becomes apparent from this discussion is that it's a time-wise calculation in terms of when is it eligible for a patent. And so the idea is we think about this question of patentability, we think of it at the time of filing the application, because the obligation at the time of application is to disclose everything for which the inventor knows that relates to that technology. It's to be candid with the Patent Office. We cannot hide certain aspects. And so here you recognize that this differs from a trade secret where we try to conceal content. With a patent, we need to make sure it's clear and understandable by others that have skill in the art and read the document. So it's a time-wise calculation from the standpoint that a predecessor might have gotten a patent, received a patent for an innovation 15 years ago, and we look at it today and say, well, that was pretty simple. My invention today is rather simple as well. It's just a couple of components and nobody's done it before. I haven't been able to buy it on Amazon.com, therefore it must be patentable. That's completely wrong because the time-wise calculation of 15 years ago does not apply to what you're standing before us holding right now as your new innovation, because we have to look at it and say, what have we learned in the intervening 15 years? And there's quite likely a lot of material that has been developed in the intervening period. So the idea is it's a time-wise calculation, and we have to think about it from the standpoint of where we stand today. What do we know at the time of the application filing, and make this determination as to what's novel and what's non-obvious and what is eligible for patent protection. So we also when it comes to preparing your patent application, these are some of the the content that you would expect to find in your application to show that these are novel configurations of components. These are non-obvious configurations of components. And when we, at the end of the patent document itself, we include what are known as claims. And the claims set forth the boundaries, if you will, the perimeter of the innovation. So the content that falls in between the boundaries represents the scope of the claim that we're looking at in our patent. So what you want to do with your patent application is to make sure that those boundaries are something that can be readily observed so that we can find where somebody might be infringing this or not. It doesn't do a lot of good if you have method claims for which an observer would have great difficulty figuring out if those steps were completed or executed as part of the process for manufacturing a particular article, for example. So we want to make sure that our claims have observable data that we can, hallmarks that we can look at and figure out if that claim was truly infringed. So when it comes to a trade secret, remember it's a matter of concealment. We're hiding, we're maintaining a secret with regard to the scope of the innovation. With regard to a patent, we're interested in disclosing as much as we know about it. So they're on opposite ends of that spectrum. And sometimes we run into situations where applicants say, well, this component over here, we'd like to keep it as a trade secret, and this component over there, we're okay with sharing that with the rest of the world with regard to a patent. These hybrid situations become particularly tricky. We have to think with regard to what goes into the claims and what's the innovation represented by this application, and does somebody need to have access to this information in order to practice it? If we're pulling punches and hiding some of the secret sauce, we may be in danger of torpedoing our patent. So you should work closely with good counsel when it comes to a blended kind of technology involving both trade secrets as well as patent-eligible subject matter. Let's talk a little bit about some strategies that are quite commonly encountered when we're thinking about patent work and intellectual property in the sense of trade secrets as well. One topic that's always on the forefront of many people's mind is, can we get a patent for this clever idea? And so the question of can we get a patent really boils down to, is it eligible for patent protection? Do we have the right type of subject matter? Is it sufficiently novel? And is it sufficiently non-obvious? And these calculations are made based on the material and information that the public knows about at the time of the application filing. And that information is not limited to patent information, and it's not limited to commercially available products and services that we can find in the market. So the question of patentability is this question again with regard to society's knowledge base is continuously growing, and what do we know today? And we don't need to care about whether it's a patent or whether it's a non-patent document or it's available commercially or otherwise. On the other hand, another question that people often ask is, will I get in trouble if I start manufacturing this product and start selling them on the market? And so now we're asking a question regarding freedom to operate. Is this technology that we're looking at something that we can commercialize and not run into problems with? Because third parties hold patents on these different innovations that we wrap up into our product offering. So freedom to operate is a question now regarding third-party patents. And we look at the innovation that you are ready to launch in terms of a commercial product. So we need to understand exactly what the commercial product is, and we need to understand what valid claims are in the world or held by third parties that might touch on what I'm trying to commercialize. So the question of freedom to operate looks at claims of valid patents and compares it to a commercialized embodiment of the innovation. And a patentability question, on the other hand, looks at all of the information that's readily available, and we compare it to the concept of an innovation for which we're trying to seek a patent. So those are two separate questions. And we oftentimes see those confused and blurred, but it's important to recognize what question are we asking and what question are we trying to evaluate. These are questions that for the most part, people are interested in answering both questions. So but on the other hand, if you're not interested in commercializing it, you may think, well, I don't need to worry about that, the freedom to operate aspect. Chances are you probably still do, because a potential licensee may be interested in commercializing it. And that's the way they're going to monetize the value of that investment. So they're interested in freedom to operate, and therefore you likely are as well. So the patent is an exclusionary right. It does not give you the right to practice or perform any kind of operation or do anything in particular. A lot of times people compare a patent grant with a deed for real estate, for example, and think in terms of meets and bounds and the boundary conditions that define the real estate property that we're looking at. And that analogy breaks down because in your own backyard, you can do quite a lot of different things. And so you have a lot of freedom to operate, but there are certain things for which you may not have the right to perform. For example, in your backyard, just because it's sizable enough doesn't mean you can put up a 4-story apartment building in your backyard. You'd have to still obtain governmental approval and neighbors' approvals and check your zoning ordinances and a variety of other factors to understand, do we have the freedom to operate in this space? On the other hand, you quite likely have an exclusionary right, which allows you to ask your neighbor to move their picnic from your backyard to somebody else's backyard. So you have the right to exclude, but you may not have the right to practice and conduct any kind of an operation that you'd like to do in your backyard. So that's the freedom to operate and the patentability question. I think they're important to keep in mind, and it's valuable to ask the right question and conduct the proper examination to understand whether we have the freedom to operate or the right to get a patent. So, freedom to operate, we're asking about authorization for making or selling, and here we're looking at valid claims held by others. In patentability, we're looking for a clever idea, something that has not been done before and that represents some sort of synergistic improvement, something that, wow, I didn't expect it to work quite like that. I didn't know it was going to have that kind of a benefit or feature or aspect. And so those are the kinds of innovations that really make it easy to get a patent, and they're robust from the standpoint that they are difficult to challenge later on if you can demonstrate clearly that we've got an innovation here that has a synergistic value. So there are other factors that go into the patentability question. As we noted earlier, we have to have the right kind of subject matter. We have to have an adequate description of the innovation. We call that the written description requirement. We also have, we talk about a best mode. And so that requires an applicant to understand what configuration is the preferred configuration. That requirement has been substantially relaxed in recent years, but nevertheless, it's valuable to have crystallized that in your own mind from the standpoint that you make sure that configuration is part of the claim scope when you file your application. And then we also talked a little bit about novelty. It has to be new, and it has to be non-obvious. These are some of the important questions. Usually it's the novel and non-obvious aspect that people run into for stumbling blocks when it comes to patent application and prosecuting applications. So a little bit more on patentability. Eligible subject matter. You're looking for something that pushes the envelope, something that makes a contribution that others were not looking at or were not expecting. So maybe you turned a component upside down, and when you did that, it operated entirely based on a different principle of operation, and it delivered performance you were surprised to see. That's a pretty golden kind of an innovation, something for which you can likely expect to a favorable review from the Patent and Trademark Office. So we're looking for synergy, something that this is more than just can't find it on the commercial market right now. It has to be something that's special. The written description requirement gets to the question of what are the particulars, what kind of relationships between these different components have to be articulated in your claims and have to be present in order for this thing to actually work. And that's part of that bargain where we have to share all of the ingredients and all of the details with regard to what the applicant and the inventor knows about the innovation. And those are some of the factors that the Patent Office will consider when it comes to making determinations as to novelty and non-obviousness. So when it comes to developing a portfolio, I think it usually makes sense to have a sharp focus on a domestic market at the outset. That's just filing applications in the United States at the U.S. Patent and Trademark Office. And from that standpoint, you will get a better value. You will have, you can file more applications. It's quite a bit less expensive to file patent applications in the United States relative to what you might encounter in other lands. Make sure when you file your applications, you're filing with a specific purpose. What kind of an objective do you really have for this filing? Is it going to be used in terms of enforcement? Are you going to use it to stop others from practicing in an area that's close to or right on top of the innovation for which you have developed? And are you looking for this filing to just get your foot in the door and demonstrate some sort of technical expertise to a constituent, perhaps an employee, a prospective employee, or perhaps an investor? Sometimes investors look for patent applications filed. They prefer to see patents that are granted. They prefer to see a sizable portfolio. But for some investors, simply because you have a patent can be quite valuable and induce an investment where otherwise you might not. So for purposes of investors and arranging partners, it can be quite valuable to have patents. And then you have to ask yourself, well, what kind of scope do I really need for this patent to have? And how many bites can I take at this apple? And can I return for a broader set of claims, for example, or additional set of claims directed to the same subject matter in a later filing, what's known as a continuation application? And for the most part, those are viable strategies when it comes to prosecuting a patent application. And so it's important to think in terms of, okay, are we using this application as a mechanism to weed out and find what art the examiner will be considering and thinking about? And so we may file an application with a set of claims directed to a subject matter that's interesting, but not really close to the core, because we still are trying to hammer out some of the details regarding the technical scope, what kind of configurations are going to be important. And so we'll save this for a prosecution at a later date. So these are factors that an applicant might consider when it comes to what kind of an application to prepare. So the scope of the application should be right-sized with regard to what content you put into the application, and that's limited, of course, by budgets or available resources. So we don't have the time necessarily to write comprehensive descriptions for inventions A through Z, and so it's valuable if we can figure out that all of the vowels are pretty important. Let's make sure we have claims directed and technical description directed to those aspects and make that the sharp focus. And if we're wasting our time on all the different consonants, maybe we should reconsider why we're filing this application and try to sharpen up the focus in a valuable way. So watch the budget. These applications can get incredibly expensive. If you're spending time writing content to describe a configuration, nobody's going to practice. It's impractical, and it's not important for the success of the business. So let's move off of that and stay focused on the right size claim scope and right-sized application. So in terms of a portfolio, the domestic market and the domestic filings of applications, I think, is a valuable strategy. For the very, very best ideas, it's probably important to think with regard to international filings. But it's probably not your first application. It's probably not some of the early ones either. It might be some of the later applications where you say, well, this has got some commercial value outside of the United States. Let's file an application there. We see far too often applicants filing an international application early on in the process and then later canceling those applications, and that's a costly path to follow. So you're better off making sure that you're absolutely certain that this is going to have an international appeal before you file your application, because you got to be prepared to protect that innovation. You have to be prepared to litigate that patent that eventually results, and that probably means sending a team of attorneys to a foreign country and spending months litigating an innovation. So not a lot of startup companies are in a good position to pursue that kind of a filing. So you're better off filing in the United States, where you can afford to launch an enforcement mechanism if that's what's called for. Among the costs that you're looking at when it comes to international filings, you're often looking at translations from one language to another. You may have to, maybe it's limited to requirements for translating the claims only or the entire specification, and when are those translations due? It may come at different times, and it may fit your budget, it may not. You're often looking at hiring 2 law firms, because the second law firm is in the local jurisdiction where you're interested in prosecuting your application, and that's doubly expensive to have 2 firms working on one application. And then the patentability rules across different jurisdictions you'll find that they vary from one country to the next. So we have different patent claim strategies with regard to how we write applications and how we write claims. So it's not a natural transition to convert a U.S. style claim to a European application claim. They have preferences, they have different stylistic considerations. It's not a one-for-one. And you also may encounter different working requirements, oral proceedings, oppositions, and appeal processes that will be substantially different than you're familiar with here in the United States. And so for a variety of different reasons, the international filing strategy is quite costly, and you need to make sure that every application you put into the international forum is the right application. You don't want to waste your resources. So the patent prosecution highway is a mechanism that you should be aware of, because it provides an opportunity to leverage the results of one patent office in the world with regard to prosecution in front of another patent office in the world. So that's the patent prosecution highway. Can have some benefits in certain jurisdictions. It's not given much weight, so it's a mixed bag, but it's worth considering that avenue for accelerating the movement to your patent application through a patent office. Keep in mind too, with an international patent portfolio, you're looking at annuity payments that are due. These are annual payments that are due, whether it's an application or whether it's a patent, and they're continuously due. And so you have to maintain these due dates in your docketing system and make sure that you don't miss the opportunity to make a payment or you're at the risk of having your application or your patent lapse. So to keep it alive, you need to continue to make these annuity payments. Timing can be a challenge because we don't have these offices synchronized with each other. So you might have one office of the world give you an office action calling for you to make some changes or explanations or arguments as to patentability. And another office of the world is completely hunky-dory with what you've submitted, and so they're not asking for you to explain or make amendments. So the challenge becomes dealing with this lack of synchronous, this asynchronous aspect with regard to the offices of the world. And the frustration and the challenge for the applicant is that one office might require a change or an explanation or limiting language in some manner, but another office might not require that same change. And so you have this divergence between one office and another office. And so the effect of that is the claims that were granted in the United States might not be exactly the same as claims that were granted, for example, in Canada or some other jurisdiction. And so you might look at your patent portfolio and say, well, one application filed in 6 countries, it's all the same. That's not the case. They'll have different scopes based on the changes in the prosecution, based on the outcome and how the examiner interprets it and what they do with the applications the claims that you submit in your application. So timing as to the prosecution from one office to the next can lead to some challenges with regard to harmonizing the scope of patent coverage in one country compared to the scope of patent coverage in another country. And this leads to another challenge too, because as an applicant, you may be faced with 3 different office actions from 3 different countries, and you want to take a position that harmonizes those claims and arguments to the best of your ability. And if you don't have, if there are still countries and jurisdictions for which you've not seen any kind of an office action, it's hard to make a change consistent with what they might find persuasive. So applicants can face some formidable challenges trying to achieve a harmonized portfolio for one application across different jurisdictions. Another consideration that's going to play into the calculation when it comes to where to file in international patent portfolio development, you have a lot of changes in the law. We've all seen here not long ago the changes that were brought about with the Brexit selection. And we also now are faced with a change in Europe concerning what is known as the unitary patent, and we have a unified patent court system that is coming online. As of the moment of this recording, we're in a sunrise period, and that will change in short order, and we will be out of the sunrise period, and now we'll be in this transition period. And there are decisions and choices that applicants need to think about with regard to how to navigate that space in Europe. So that's another change that's coming. Regional offices have different changes from time to time as well. In Europe, for example, there are new guidelines that are presently soliciting feedback and comments, and this creates a situation, these guidelines sets forth a situation which changes the scope of the patent application that you might be filing. And in Russia, for example, we are now in a situation where it's very, very difficult or challenging for a United States patent office or patent attorney to send payments to maintain a pending application in Russia, for example. And other countries of the world are looking at compulsory licensing measures that will touch on some of the technologies you may be faced with in terms of development. So there's a lot of different legal challenges and jurisdictional dynamics that'll impact your patent portfolio development plans. So we've here been talking mostly about what is known as a utility application. That is some kind of an application that covers a device or a system or a method that has some utilitarian value. It does something for somebody, or it makes a process easier, or it simplifies a job There are also patents available for designs in the United States. We think of a design patent directed to ornamental aspects. So these are not utilitarian functions. And in fact, if you have utilitarian functions wrapped up in the design, the artistic elements of your configuration, that can cut against you with regard to applying for a design patent, because it now has utility as well. And so you have to make a choice at some stage of the process. Are we interested in a patent for the design, the ornamental aspects, or are we interested in the utility aspects as well? And so there's another divergence that you have to consider in terms of the choices to be made. So in most parts of the world, we think of an industrial design. In the United States, we think in terms of a design patent application. Other parts of the world have what are known as utility model patents. And a utility model patent is a slightly different version of a patent grant, usually for a shorter duration, and it reverses the sequence of events that we're often familiar with here in the United States. Here in the U.S., it's an application process for a patent whereby we develop a technology, we write an application, the application is scrutinized in a process known as prosecution, and at the end of it, if it meets the requirements, the patent is granted, and then it can be enforced. With a utility model, on the other hand, it's almost a registration process, and you supply your application, you pay the fee, you get a patent. If it's challenged, that's when it gets scrutinized for patentability. Does it have legs to stand on? So it's a slightly different kind of a flavor, and that's another option that you'll find available in many countries of the world. So we also have plant patents as well. So this is another variety of a patent protected technology. And if you're working in that space, you'll become quite familiar with plant patents and those variations. In terms of international filing, there's another mechanism that you should be aware of, and it's called the Patent Cooperation Treaty, or PCT. And this is a mechanism administered by the World Intellectual Property Organization, headquartered in Geneva. And what they offer is an opportunity to file one application as a PCT application, and that has weight for about 155 different countries of the world. And so the PCT application is searched and examined, and then at the end of that process, you get a search report, and that search report gives you the insights with regard, and a written opinion that gives you the insights with regard to what subject matter is eligible for protection. Where should we take this in terms of what countries we'd like to file this in? So at the end of the PCT process, you're invited to file your application in any one or any number of 155 different countries, and then that office will take the search report from the PCT and make their own independent search and examination calculations and either grant or deny the patent application for you there. So the PCT is a mechanism, it's a gateway to 155 different countries. There are some important markets that are not included in that, so be mindful of what member countries are part of the PCT process. Keep in mind, too, that it adds to the cost, because now you have one body that conducts the search and examination, and they charge for that service. And then they also charge for administering and coordinating with all the other offices of the world. So it's a costly endeavor, but it does get you an opportunity to delay the decision as to what countries to choose for your patent portfolio. But it also gives you insights as to patentability for the claims in your application, but there are some burdens that go with that as well. So it's an added mechanism, it adds delay, and it adds some costs. And if it fits your business plan, it's a valuable strategy for many filings in many different countries of the world. There are strategies and appeal mechanisms under the PCT as well. So the prosecution there can take a wide variety of different paths. So returning again to a domestic filing strategy, let's talk for a moment about a continuation application. And a continuation application is a mechanism by which we get to say, the applicant gets to say, I'd like to pursue additional claims already disclosed in the application. And so we're going to use the same specification. We're going to pursue some different claims now. And so the subject matter disclosed remains consistent, but the claim scope is changed. And this is a valuable strategy for an applicant if they're interested in maintaining continuity. And what maintaining continuity amounts to is it tells the world that we're still interested in harvesting some clever ideas from this one application. And it has an interesting effect with regard to third parties from the standpoint that it can deter them from challenging your application. Because if you had a single application and it turned into a single patent, there's little or no opportunity to adjust the scope. However, with a continuation application still pending, you have a lot of opportunities to adjust the scope of the claims. And so if a challenger pushes back against an application where there's no continuations in the pipeline, then the forms have already been set for the concrete sidewalk we're pouring, and there's little or no opportunity to make adjustments. On the other hand, if a challenger files an action challenging a patent for which there's a continuation pending, the applicant still has an opportunity to adjust positions. And so it can frustrate the objectives of a challenger by keeping a continuation pending. Now there's some costs associated with filing a continuation application. You have to prepare new claims, you have to file new fees, submit new additional fees, and you have to prosecute and maintain it with with maintenance fees after the time of grant. So it's non-trivial costs, but it's a nice mechanism to deter others from challenging your patents. And it also gives you an opportunity to deal with late discovered art that might otherwise challenge some of the claims that you received in the earlier filing. With a continuation application, it enjoys the same priority date as the earlier filing that is the parent, that's known as the parent. And so that earlier filing date remains the date by which we test the question as to novelty and non-obviousness. So that's a valuable point to keep in mind because you get the benefit of that earlier filing. The downside, however, is that the patent term is measured from that earlier filing date. And so with continuation filings, the period you can expect for exclusivity is reducing. So it's shrunk by the prosecution time for the first one, for example. Now, with regard to new matter, sometimes people say, well, we've continued to develop some interesting ideas, and now we'd like to pack some of these new ideas into our application. And this is what is known as continuation in part. So it's an expansion of the claims, and it's an expansion of the subject matter, the specification, the content disclosed in the application. And the interesting thing with a continuation in part application is it comes with a second priority date. So we have the first priority date for the base material and a second priority date for the date of the filing of the expanded application. And this two priority date phenomena associated with a continuation in part application leads to all sorts of downstream effects, most of which are detrimental to the applicant and troublesome for the examiners and fruitful opportunities for challengers. So for the most part, you won't find a lot of folks filing continuation in part applications. So When it comes to the domestic strategies, I want to talk a little bit more about the timing for prosecution and the application itself. With regard to domestic filing, there are opportunities to accelerate the examination of the application. And why would you want to accelerate examination? Well, the period of exclusivity arises at the time of grant, and it expires at the time of the patent lapse, or at the end of the 20-year nominal term. And so people want to maximize the exclusionary period. They may choose to accelerate the prosecution of their application. And there are a number of different mechanisms available. These are made available by the Patent and Trademark Office. And these mechanisms give us the opportunity to speed things up. And they can be quite valuable. One in particular is known as Track 1. We also have already spoke about the patent prosecution highway as one particular mechanism. The Track 1 application process at the U.S. Patent and Trademark Office is a benefit after having paid a fee, currently around $2,000 for a non-large entity, $4,000 for a large entity, and that fee gets a promise of a final determination within 12 months. So in addition to the Track 1 mechanism that's available and the patent prosecution highway, the Patent and Trademark Office also makes available a number of different special programs which also come with to the front of the line treatment of your application. One of those is a green technology program. So if your technology is a mechanism is directed to technology for example, ethanol, wind energy, solar technology, so that things of that sort, you may be eligible for participation in a green technology acceleration program. And there are other programs as well directed to inventors of a certain age, or technologies directed to certain pandemic kind of related topics and technologies that we've seen in the past. So look for those opportunities as well. Now, in addition to accelerating your application through the Patent Office, you may also find it valuable to be able to decelerate the rate of prosecution. And why would you want to slow things down? Well, you may be interested in spreading out the costs and the money burn rate. You may be interested in coordinating timing with regard to an FDA approval process, for example, or some other kind of influx of cash as part of your business plan for this business. So how can we decelerate? We can file. There's a number of mechanisms that are easily available for short-term extensions or delays. And there's a couple of mechanisms that will buy a more lengthy delay. One short-term one is to file what's known as a continuation application without submitting the fees. And the continuation application is a signal to the Patent Office that there's still more good stuff in this application. We're just not ready to figure out what parts of those we'd really like to pursue. And withholding the fees is a great way to slow down that application, because the Patent Office won't pick it up for search and examination if they've not been paid. You can buy probably about 6, 7, or 8 months with that kind of a strategy. You can file a provisional application that introduces an extension of about 12 months. You can file a PCT application to delay a decision for, let's say, 30 or 31 months. You can buy extensions on responding to an office action. So when the Patent Office sends you a letter, there's usually a 3-month period of time in which for the applicant to respond in writing, and you can buy extensions for 1 month, 2 months, or 3 months. Another mechanism to to decelerate the prosecution rate includes filing an appeal. So you get a rejection from the Patent Office, and there are fees associated with filing the appeal, but that appeal process itself can last 1, 2, maybe even 3 years in duration, so that can delay the prosecution of the application. The interesting thing with an appeal is you can also file another application and pursue some of the same technology in a different application concurrent with the appeal. And you can purchase from the Patent and Trademark Office a 3-month extension, just a submission with the Patent Office. I think it's fairly inexpensive. That can be a nice, attractive option. And there is actually a mechanism by which you can request a 3-year deferral of examination as well. So these are different mechanisms that you can invoke to decelerate the prosecution rate through the Patent and Trademark Office. Let's talk for a moment about enforcement, and I think we're kind of wrapping things up here. Enforcement mechanisms. These are mechanisms by which patentee may leverage the power of the patent grant and mechanisms by which we can shape the behavior of others, third parties. So one mechanism is licensing. Your patent, when granted, actually before it's granted too, but most folks think about it after it's granted, and that is a licensing opportunity. So you can license this technology to authorize other people to enjoy the rights that are conferred by the patent itself. And again, this is not necessarily a right to practice, but it's a right to exclude others. And so you can license that ability to a third party, for example. You can also, you may also be looking at using what is known as inter partes review as a mechanism associated with enforcement. And inter partes review is a administrative procedure conducted at the United States Patent and Trademark Office, which reviews the patent and makes a determination at the end of that process as to the claims, and it can lead to claims being invalidated, and that's a mechanism that somebody may use to challenge your patent, and it's also a mechanism you may use to challenge a troublesome patent held by others. Oftentimes, the inter partes review procedure is conducted in parallel with activities at a district court level, for example. And sometimes oftentimes the court will stop their proceedings and wait for the inter partes review proceedings to conclude before they make a determination. So there are court mechanisms and administrative mechanisms by which we can scrutinize the grant of a patent and the claims that are associated with that patent. Outside of the United States, there are a number of mechanisms too. We spoke earlier about the Unified Patent Court, and that's a European-based mechanism, and it's coming online. The first filings of which could occur as early as June of 2023. There are opposition mechanisms by which a third party can lodge a challenge against a patent that's granted or an application. There are revocation procedures. In the United States, we have discovery mechanisms that can reveal some of the workings and some of the underlying facts concerning the United States patent, but some of those discovery mechanisms are not available in many foreign jurisdictions, notably Germany, for example. Rules of evidence and appeal mechanisms are also will also vary from one country to the next. And relative costs in the United States, litigation is incredibly expensive, whereas in Europe, the costs associated with any kind of a challenge are substantially lower. The costs associated with an inter partes review mechanism, for example, is probably in the $100,000 to $500,000 kind of a dollar range. Judicial court, if you have to go to a court proceedings with a U.S. patent, you're probably talking spending upwards of millions of dollars. So it's quite costly to enforce your patent. So keep that in mind when it comes to developing your portfolio and why are we filing these applications and what are our plans. So folks, that brings us to the conclusion with regard to this introductory discussion regarding patents and strategies and leveraging your technology. Thank you for participating.